SJC-13378, Maria Blanca, Elena Garcia, and another v. Shanitqua, Steele, and another.
Okay, Attorney Antonelli, whenever you're ready.
May it please the court. Good morning, Your Honor. Your Honors, Peter Antonelli on behalf of the plaintiffs, Maria Elena Garcia, and Jose Fafian Sejo. Before the court is really a legal issue under the Graves Amendment, 49 U.S.C. 30106. We believe, and it's our position, that the Superior Court erred in finding that the Graves Amendment applied to the transaction at issue, which was a courtesy loaner car. The plain reading of the statute covers the lease and the rental of cars. The record before the court demonstrates that the courtesy loaner vehicle.
Can you address the 11th Circuit's take on consideration that you know, because we have two cases of the circuit. Well, you obviously know the case law, but we have the 11th Circuit goes against you on this issue of consideration on lease or rental. Can you address that, please?
Your Honor, I can try. With all due respect to the 11th Circuit, I didn't find the rationale entirely understandable. Essentially, it was,
I mean, as I understand this, is part and parcel of you buying this fancy car and having this service. We're going to give you a rental, and that's the consideration.
I think what the 11th
Not a rental. I'm sorry, I misspoke. A loaner. Right.
I think what the 11th Circuit said in taking a square peg and putting it into the round hole of what was actually an ordinary and common usage for consideration, for rent, and what was consideration. The court said that when I, as the customer of the service department, have an opportunity to service my vehicle, that constitutes sufficient consideration.
So I go to the dealership. I go to the Mercedes-Benz of Caldwell to get my car serviced. I don't go to Joe's Garage because Joe's Garage is not going to give me a loaner. Isn't that part of the consideration of me going to the Mercedes-Benz deal? Because I'm going to pay for this front-end alignment, and I'm going to get a loaner.
Well, the problem with that is it's twofold. First of all, it's strained in the sense that if you take another hypo, I'm the homeowner that chooses to paint my house, and actually the consideration that I'm paying to a particular painter before I actually pay it, before I actually undertake the agreement, before I even render the agreement, is just the opportunity that I had to give that job out to 7 different painters. It just strains credulity. It really contravenes statutory construction, which is let's use the plain and ordinary and common sense meaning, which is why you look to dictionaries. Number one.
I'm sorry. No, please continue.
Number two, when I asked at deposition the CFO, the 30B6 representative, very simply, is there a cost associated, i.e., is there consideration paid by the customer for that? Not only did the 30B6 representative not say, well, I don't know what you mean. There's a lot of ways to construe that. She understood the plain and ordinary meaning of the question that I was asking and said no.
I'll expose my naivete. I was struck by the fact that there are 125 vehicles that are loaners. This is a big business. Doesn't that more go to this cost associated with maintaining those 125 vehicles that are passed on to the person who's getting the car fixed? Well,
certainly the dealership can maintain its business of servicing the car, and it can do what any number of dealerships do, which is maintain an independent rental agency within the dealership. It can give the customer an Uber ride, right? It could say, we don't want to give you any rental at all. It could say any number of things, and my point there is it's separate, it's independent from the transaction, and the court need look no further than the actual rental document, because the rental document has
lack of a rental document.
Right, it's not a rental document. The dealership calls it a loaner authorization form, and front and center is a placeholder for cost and it's zero, right? It doesn't say what the 11th Circuit says, which is, well, for this particular transaction, we're going to call it an opportunity, right? And so
Well, we're going to charge you, $1,000 for the front end alignment rather than $800 that Joe's Garage does, basically.
Well, again, I think anybody construing this has a hard time finding consideration.
I see what you're saying. It's a search and inquiry for consideration.
Right.
But let me ask you a different question then,
Sure.
because I think it's as straightforward as that, whether there's consideration. But one of the decisions talked about the statutory purpose of the Graves Amendment, and that this failure to hold the business liable would be inconsistent with the statutory purpose. What do you understand the purpose of the Graves Amendment to be, and whether or not your interpretation fits in with that purpose?
Sure. I think, first of all, when construing a statute, a federal statute.
Yeah, this is probably third in the toolbox, but
Right. So if we get past the plain terms, and we need to go past dictionaries, and then we need to look at what is the statutory purpose, which I understand under the rules of construction is part and parcel of the first two steps. Okay. The statute was enacted in 2005 to afford protections to rental car companies and leasing companies, not just necessarily private individual rental cars that operate in interstate markets. And
so they don't get sued in California when they rent it in Virginia.
Right. And so the Congress made a decision to bolster that business by affording liability protection on a countrywide basis so as to preempt individual state laws that might impose liability on a particular national rental chain in a particular state. That was the purpose.
Where does the 100 miles radius fit into that inquiry?
Well, it fits in, I believe, that in the sense that generally for Congress to act in a case like this, it's operating under its powers under the Commerce Clause. And I think it was the GMC case, also by the 11th Circuit, cited by my brother. The court analyzed under Raich, I think, that where you have activities that substantially affect, that's the test under Raich, substantially affect interstate commerce, then Congress has the power to act. So it goes to both the purpose and it goes to both the power of Congress to act. In other words, here we have a situation where the local dealer, much like many dealers, most dealers perhaps, are operating in a localized environment, at least vis-a-vis national rental companies, national truck rental companies, auto rental companies. And so it doesn't fit within the purpose, right? And then as to the power, it undercuts the proposition that Congress was acting under its interstate commerce powers. Because obviously the dealership is telling its customers don't go more than 100 miles. And in most circumstances, unless you live in a border state, that's going to restrict the loan of the vehicle to that particular state. So I think it cuts on both those points.
Can I ask a sort of a silly question? Am I cutting you off, Justice Garcia?
No, I'm all set. Thank you.
As much as we love deciding complicated federal statutory questions, how isn't there's no possibility of negligence here on the part of this company, right? I mean, the lease is the rental agreement is with her husband or her boyfriend, I can't remember who he is. He's not driving the car. She's driving the car. Don't they preclude him from letting anyone else drive the car? So should we be even deciding this difficult federal question in a case in which there's no possibility of proving negligence against the company?
I think that's one argument, that the court need not reach that. But here we're arguing, obviously, that there is liability based upon essentially respondeat superior
You go
applying.
by the statute.
Yeah, applying 85A, right, and 231-85A. And number two,
Meaning that if they're the owner, okay, so your point is that if we rule the other way, there's a presumption that they're the owner. There's not a presumption that there's negligence, right?
well, I've read the case law. Judge Gantz in the, I believe it's the St. Pierre v. Penske truck case, while he was a Superior Court Justice, traced the arc of the development of 85A, and
It's prima facie evidence of responsibility.
It's not only prima facie evidence, but where he came out in 2001 was that the SJC creates, the SJC has applied that statute in such a way that the question of the presumption goes to a jury. Okay, so that's number one. Number two is on the question of liability. Admittedly, this is a question before the court, right? It's a question of what is a legal question of whether or not there's a duty, and then because I found no case that was foursquare on the circumstances of this case. There are a couple cases. I think it's Jupin, which dealt with the court, the SJC, imposing a new burden on a homeowner whose boyfriend had firearms and created a burden. And so it's an issue of law, and those are duties that evolve.
And the judge below didn't reach this issue.
What's that?
The judge below didn't reach this issue.
The judge did reach the issue, and he said unequivocally there is no duty under the circumstances of the case. And I submit that there is a duty, and there should be a duty, because
He said that notwithstanding the Graves Amendment.
yeah, he reasoned that there was no duty under the circumstances.
Because I was
of
more
this case.
I was more looking at whether or not Mr. Oki was liable for negligent entrustment.
Well, I just heard Your Honor's question as whether or not there was a duty as to the dealership.
Right, yeah,
And
that
he reasoned that there was no duty under the circumstances of this case because the conduct was not foreseeable. Ultimately, that Oki entrusting the car to his wife, and his wife, who was an unlicensed driver, was not a foreseeable injury such that was a duty. And what the adjustment, I think it's the Jupin case, obviously the court, whether or not there's a duty is a matter of law, and then we get to the question of what is the scope of the duty, and that becomes a factual interest. And I submit to the court that under the circumstances of this case, where you have a Mercedes dealership renting out high-end cars that generates $10 to $15 million just in its parts and service business, because that's what Mr. Pittman testified to in his deposition, and that's before the court, that there should be a duty. In other words, they're in the best position to assess the risk of giving out these loaner vehicles. They've decided that it helps their business to do that, but they have options. They can give a customer a rental voucher. They can give the customer an Uber ride. And this court is not blind to those options. Those are everyday options. The dealership could put a low jack on the vehicle that says that enforces the distance limitation. The record testimony is they don't do anything. They don't check to see that their policies and procedures are being enforced. So, as Justice Scalia said, quoting one of the founding fathers, it's a parchment guarantee. It's just a piece of paper, in their words. So I submit that
That's mostly what we deal with, parchment guarantees, so you don't want to put us out of business.
I don't. On the negligence, I have 49 seconds. So on the negligent entrustment, I read Judge Deacon's decision and my brother's briefing to say that because Mr. Oki testified and because Steele testified that I didn't have express permission to drive that car, that's enough. It doesn't get to a jury. And our position is, regardless of what they said authority.
Well, he left it running with her.
Right,
in the front
so you
seat.
can have, so the test under the negligent entrustment doctrine is whether there's specific or general permission. And our position is, if,
Well, the parking lot, the parking enforcement person thought she had permission to move it, to.
everybody
drive it.
seemed to think it, and there's no dispute. Your honors can look to the incident report, the detective that investigated it, that was happened to be on the scene, Detective McManus, observed the incident. He saw her behind the wheel of the car. OK admitted that he left her in the car running. So the circumstances of the case, I would submit, show implied permission. But in any event, it's something that a jury should decide under the circumstances of the case. Looks like I'm over, I believe, so I'll rest there. Thank you.
Thank you. Okay, Attorney Melville.
May it please the court, Michael Melville on behalf of MBF Auto doing business in Mercedes-Benz of Caldwell and MBB Auto doing business in Mercedes-Benz of Brooklyn. We ask the court affirm the judgment of the trial court. As there's really no evidence of negligence in this case, the plaintiffs have to rely on the prima facie assumptions created by 231-85A. But that statute, one, with regard to MBB,
Does that get you over the rail to a jury trial?
well, we were granted summary judgment on this, Your Honor, and in my opinion on 85A, just in general, first of all, it's preempted by the Graves Amendments, but secondly, as far as just, if we just wanted to focus on whether or not you need to apply 85A, while there's some rather old SJC case law, I think it's the most recent case was the 40s, more recent appellate authority in Massachusetts has indicated that summary judgment can be appropriate. I think it was the appeals court, not this court, so it's persuasive authority, but I believe Thompson's case said you can overcome that presumption of 85A at the summary judgment stage.
Let's go to the Graves Amendment. What's your view of the consideration? Does it have to be dollars for consideration, or could it be this kind of goodwill?
Well, it's not goodwill, Your Honor, in these circumstances. It doesn't have to be dollars. Consideration is never been anywhere, and it's not limited to dollars. Consideration is something which motivates a person to do another act. In this case, the consideration is if you bring your car into a dealership and it meets certain criteria, including that it has to be there for more than 3 hours, so presumably larger repairs, not just an oil change or whatever, we will provide you with a courtesy vehicle as part of it. And you only get that courtesy vehicle not for an unlimited period of time. You have to return within 24 hours of our service being done. So it's very clearly tied into the requirements and business of this vehicle.
But Mr. Oki doesn't believe he paid anything for the loaner vehicle, right? He got it as a gratuity for the service.
Well, no, Your Honor, while he may have said that he didn't pay anything for it, he brought it into he chose to come into a Mercedes-Benz, a dealership, pay presumably higher prices as part of that, as part of his calculation of where do I bring my vehicle? Do I bring it to Joe's Auto, as Your Honor referred to as, or do I go into a Mercedes-Benz dealer where I might pay a higher rate per hour for work, a premium on prices, the same part, the same service? It motivated him to go to the dealership. As he indicated, I think in his testimony, I always go to dealerships. Well, why does he do that? He goes there because it gives him additional services in addition to having his vehicle repaired.
What's your understanding of the statutory purpose of the amendment?
Well, the statutory purpose of the amendment, Your Honor, it's under the Congress enacted and under the Commerce Clause. The Commerce Clause allows Congress to do several things, but the large one, I think Garcia in the 11th Circuit noted, allows them to regulate purely intrastate activities which have a substantial factor on interstate commerce. The repair of vehicles, an instrumentality of commerce, has a substantial impact on the interstate commerce. This is allowing him, first of all, I would dispute that this activity of this company is purely intrastate. 100 miles from Caldwell, New Jersey.
He wasn't supposed to be there.
Well, he wasn't supposed to be in Massachusetts, but 100 miles will bring you to Philadelphia or New Haven, Connecticut from Caldwell. New York City is still within that 100 miles.
Well, let me, what do we make of the fact that it doesn't say bailments, it just says leases or rentals?
Well, Your Honor, I assume you're talking about the statute saying lease, yes. Well, it doesn't say bailment, and first of all, I think a rental, even if I pay money to rent to enterprise, that is a bailment. The terms in the statute are lease or rent. And those terms, this fits that, which is a rent is, well, I think we look at the 2004 version of Black's, which doesn't define rent as a verb.
Everybody cites the definitions of both sides.
Yeah, it does, but well, you don't have to look at...
Question is how do we define
rent.
Consideration in this transaction?
Yeah, and it was an activity that motivated him, or it motivated a consumer, rather, to bring their vehicle.
And maybe I should have looked, and maybe it's not before me, but what did he say in his deposition as far as that goes?
I'm not sure that what his motivation was explicitly asked. This particular individual's motivation was asked, and I'm not sure it's necessary to interpret the statute. As you know, I don't know why.
I'm getting more to the brass tacks. Was he asked about why he went to the Mercedes dealer and whether or not the rental cars or the loaner cars were part of his reasoning?
I don't recall that was actually part of the record, if that was ever asked of him, Your Honor. I was not the trial attorney on this case, but I don't recall that was in the part of the record of this case. I believe he said he brought it in to get it repaired.
His individual intent wouldn't really matter.
Exactly, Your Honor. That was more my point. I'm not sure that his intent matters. Is this consideration for the transaction?
The company is giving a detriment, which is it meets contractual definition of consideration. I don't know if it meets the definition of rent or lease, but it satisfies the meaning of consideration, doesn't it, under contract law? They're suffering a detriment. In return for getting the ability to repair his car and make some money, they're providing this, car to him, so that gives him a benefit and it's a detriment to them. So, it seems like it's going to meet some definition of consideration, but
I agree, Your Honor, that was more...
11th Circuit's embellishment of rent or lease.
Well, Your Honor, and I think you have to go back to break down what a rent or a lease is, which is I'm giving someone a piece of the temporary use of property in exchange for consideration. That's when you get back to the consideration. This meets the definition of it. It doesn't need to necessarily be a dollar figure. That if Congress, wanted to, include a dollar requirement that a dollar figure be part of the transaction, it could have done so. It did not do so. It said a rent or lease, in the definition of common parlance of rent or lease, is a temporary granting of property in exchange for consideration. And this meets the definition.
I'm sorry, I'm slow today, but so, and probably always. So your client gave the plaintiff a loaner car, and the consideration for that loaner was the opportunity to repair the car.
Correct.
As opposed to him going to Joe's.
Correct. It's a opportunity for him to come in and repair the car. It doesn't need to specifically be a dollar.
You have, and so there's two parts of the Graves Amendment. So you are saying that you're the owner that rented or leased the vehicle, and the consideration was the opportunity to get. So how do you meet the engaged in the business of renting and leasing? Is that because your fleet is so large?
Well, it's part of, I think, one, they're a car dealership that leases vehicles in general. But besides that, with regards to this specific issue here, Your Honor, yes, in addition to being a car dealership that leases vehicles to other consumers, not long-term leases, as Mercedes-Benz is wont to do, they also, and this is part of they have a very large repair business. That repair business has a fleet of 125 vehicles. 95% of them on any given day are out on loaner. Part of that repair business also is enticing people to come in as it's part and parcel of the whole business, the whole repair package.
And
together.
Can you cite for me again that Commerce Clause case that is really about the breadth of the Commerce Clause? It's really, really hardly a limit at all. You had discussed it earlier in oral
yeah,
argument. I
if
can
we-
just listen back to the tape if you don't have
Yeah,
it.
it was Garcia, Your Honor, I believe was the case. It was the 11th Circuit case cited in my brief. Well, there was two. Thayer didn't have to deal with the Commerce Clause because the 11th Circuit itself had already found it was constitutional statute and it wasn't a constitutional challenge on Thayer, or in this case, really either. They didn't really challenge the constitutionality of it, but it's the Commerce Clause, by and large, the Graves Amendment, almost, I believe every time it's been challenged, has been found to be constitutional by the federal courts, at least the circuit courts of appeal, at least as far as I'm aware. With no other questions, we'll rest on our brief. Thank you.
And Attorney Lentini gets a chance.
Good afternoon, Your Honors. May it please the court. David Lentini on behalf of the defendant, Kolawole Oki. The sole claim against Mr. Oki is for one in negligent entrustment of the vehicle to Ms. Steele, causing the accident.
Is that the only claim against Mr. Oki in the complaint?
There's also a claim for consortium, Your Honor. Only summary judgment was entered as to the negligent entrustment claim, count two.
And how is it that if you double park a car, leave somebody who can't drive in the vehicle with the car running, not negligent entrustment?
The foreseeability issue, Your Honor, I'll get right to it. Was it foreseeable? I guess that's the question to Mr. Oki, whether Ms. Steele was going to.
It's right down there during business hours. It's
It
not
is.
out in a field in Iowa.
Understandable. But there's also, I think everyone in this room has been in a car, an occupant of a vehicle, when the owner or the operator gets out and runs into the convenience store with the car running.
So that the person in the passenger seat can move the car if need be.
If there was such evidence in a discussion, Your Honor, I
Well,
would agree.
But you don't even have to,
Aren't you at summary judgment?
We were, Your Honor. And there was affirmative evidence from Ms. Steele and Mr. Oki that she didn't have a license. He knew this. She never tried to drive one of his cars. For all we know, he could have left her there as, for lack of a better description, a human scarecrow for meter maid came along, seeing that this car is running, the lights are there. They're obviously not going to be here for a long time. I'm just going to go down the street. If there was some evidence that they had a discussion, move the car, I wouldn't get summary judgment, and I would have never moved for it. But there was no discussion amongst them, and I would.
Why would he leave the car running?
That's a great question, Your Honor, and that is.
One for the jury, probably.
I believe it's not when there's affirmative evidence, Your Honors, that the.
Must have been hot. Keep the air conditioner on.
We're guessing. It's speculation as to why he left her there, but he knew she couldn't drive it, and she literally said.
Is it really guesswork, though? I mean, isn't it a fair inference? And on summary judgment, we indulge the fair inferences in favor of the non-movement.
But she said, I didn't have permission to drive the car in her interrogatories, and that's her testimony. That's affirmative evidence that she knew she did not have consent to operate the vehicle. And there's been nothing to refute that. And the plaintiff's only real argument is that it was a matter of implied consent. And that seems to be, and the only case they cite in their portion of the brief addressing this is the O'Leary v. Fox case. And that's it's kind of convoluted, similar to this, but that was two motorcycles crashing, and they found that the owner, the operator, they found the owner liable under a negligent entrustment theory because the owner saw that the operator bought the bike on her credit card.
is that a summary judgment case?
I thought usually these cases are kids that take a parent's car for a joyride, and there's evidence the parents never allowed the kid in this. You can have summary judgment there. This is a little different, right?
I don't really see a lot of difference. If there was, again, there's just no affirmative evidence, and we're on summary judgment as to why, she was sitting in the car. If there was, again, this wouldn't be a summary judgment case, but, for those reasons, I would just respectfully request the court uphold the lower court's decision, and I would rest on my brief unless there's any further questions from the court.
Thank you.